Welcome back to another episode of Litigious, the number one podcast in the world for legal discussion or discussion of legal topics in the news. I am Scott Peterson. Giovanna is here with me as always. We are here to break down and give you a common sense take on stories across the board. Reminder, this podcast is brought to you by DeRazio Peterson, PC, a catastrophic and serious injury and employment law firm in New York, also handling cases in Massachusetts and Vermont. If you have questions, visit us online at DeRazioPeterson.com, or you can check us out on any of the socials at DeRazio Peterson. If you have questions for the podcast, you can message us at Litigious Podcast on Instagram. And as always, if you're enjoying the podcast, like, subscribe, share, do all those things. And we've got a burner of an episode today. Lots of topics to talk about. It's been a couple weeks, lots of stuff in the news. We're going to start with a lawsuit that was filed by FBI Director Kash Patel against the Atlantic magazine this week. And the backstory here is interesting because I think for some time during his tenure, there's been some sort of stories and rumors about Kash Patel uh, liking to have a good time, apparently enjoying partying, enjoying drinking. Anyone who was paying attention during the Olympics probably remembers after the USA hockey team won the gold medal, he was in the locker room, shotgunning some beers with the boys and having a good time. And this past week, the Atlantic ran a very long, very what I would consider to be well reported and detailed article about some of the concerns within the FBI and in the administration more generally about Patel's drinking problems, about his alleged uh, visible intoxication at events. They assert that security has had a difficult time waking him up at times. He's missed things. He's had freakouts. All these sorts of things. It ran last week in the Atlantic. I read it when it came out. It was good. Didn't think too much of it. And then Patel immediately went on the offensive, threatened to file a lawsuit, and this week did file I think $250 million lawsuit against the Atlantic. In his complaint, he accuses the defendants of publishing an article replete with false and obviously fabricated allegations designed to destroy his reputation and drive him from office. Pushback against the allegations that he drinks to the point of obvious intoxication uh, indicates that he does not, in fact, drink to excess at the establishments that were highlighted in the article or anywhere else,
Oh yeah,
and that this is
even though we
this is
all saw it.
yeah, and this has never been a source of concern across the government. Apparently, they claim that their attorneys expressly warned the Atlantic before publication not to publish it because it had false information, and that is where we leave it. The one thing I will note, I'll turn it over to you, and you can explain why Kash Patel, in his position, faces an even higher burden in a defamation case, which, as we've discussed before, is a high burden to begin with.
Yeah, well, two things. I mean, truth is a defense to defamation. We've talked about that a lot. So when you file a defamation lawsuit as the plaintiff, you really have to be pretty careful because, I mean, if any of this is true, it's going to come out and you could potentially be shining a much larger spotlight on it than the original article even did. And the second piece of it, like you said, is he's a public figure. So the standard for defamation, liable in this case because it's written, is very high when you're a public figure. So a publication like The Atlantic, as long as they're sort of fact checking to the best of their ability and they have sources, I don't necessarily see you being successful. I mean, that being said, maybe not The Atlantic, but at least some major television networks have capitulated to President Trump himself in these types of defamation cases that legal commentators and legal scholars on the First Amendment did not think would ever be successful if they went all the way through the litigation process, but they still settled with him for large amounts of money. Now, I think President Trump is sort of an man unto himself. So I don't know that what someone, even if they're in his administration, is going to receive the same level of capitulation, that the president has.
Yeah, I think you hit the nail on the head. They have to essentially show, he essentially has to show actual malice on the part of the Atlantic in their reporting. Um, a few things. One, yes, those other news outlets capitulated to Trump exactly for the reason you said. He is a planet or a universe unto himself. He's got the ability to control the narrative. He's got the audience, the platforms to really cause major headaches for news organizations and other organizations. He's also got the power of the presidency, not for nothing, and has clearly shown his willingness not to hesitate to use that to punish his foes and outlets who that cross him, including using the FCC, for example. I, I think Cash Patel has dramatically misread this situation and overstepped what he should be doing here because I don't think for a second Trump is going to use the same power that he would use for himself to support Patel. According to the article, part of the reason for all these freakouts is because Patel is basically on his way out, and they think that the administration is going to push him out in the near future in any event. So I seriously doubt they're going to use political capital to save him. That's the first point. The second point is I looked this up. The Atlantic has 1.5 million subscribers roughly. I read the article. I have the Atlantic on my Apple News feed, so I saw it. I can't say how many people actually read it. It probably got circulated. Probably more than 1.5 million people read it, but I wouldn't assume that 10 or 20 or 30 million people read it. Then he files a lawsuit and makes a public statement about it. And now all of a sudden, this is appearing on every news media outlet in the country. So he's amplified this article probably tenfold.
Yeah,
And
and
so, go ahead.
oh no, go ahead, sorry.
And so it's this is like a classic example of what we always talk about, which is you have to pump the brakes before you jump into these legal actions because not only has he amplified it, but now if he continues with it, he's going to have to give a deposition. There's going to be discovery. They're going to want to know all about his habits, his drinking habits. They can depose people in the administration. It's just talk about opening a Pandora's box. This seems to me to be the most short-sighted decision. I mean, there's always short-sighted decisions, but this is one for the books. And we always tell clients, it's very rarely a good decision to just jump into a lawsuit 2 or 3 days after something like this happens. I understand why they did it. I think he's trying to be proactive and take the aggressive position of, you can't push me around. I'm going to defend myself. But to me, this seems like you just threw gasoline on what was probably a fire that would have burned out anyway.
Yeah, and typically what I was going to add before is like in the same vein, in most defamation cases, unless you've been accused of a crime, there's some burden on you to prove a damage to your reputation. And I understand, maybe he's going to say, oh, I'm going to lose my job because of this article. That being said, I don't know that this guy has some fantastic reputation that he needs to preserve anyway. I think look, for better or worse, if you think that it's perfectly fine for the director of the FBI to go party in a locker room with the hockey team and, act the way that he did, I don't think anybody cares about, having a drink or like doing like a high five with somebody. But the guy looked very foolish in the videos that they sent. Like it would like he reminded me of like a character in a high school movie that got wasted for the first time at a party. So the guy does not have a fantastic reputation. I think people commonly believe that he and potentially Hegseth also are like these drunk, crazy people for whether that's true or not. But I think that's the perception. I don't necessarily feel that his reputation was like totally tarnished by this article. I feel like it's probably in line with a lot of stuff that was already out there about him. And by putting the spotlight on it, he's opening himself up to the actual truth, coming out, not just, rumors about his reputation or whatever, or what he's up to. So I don't know. I think I agree. I don't really see the point. I mean, I don't know what he's trying, obviously he's trying to accomplish getting money from them. And, again, maybe he does look at the president and say, well, here is somebody who was successful in getting, 60 plus million dollars from, was it ABC or something? So maybe he thinks that that's gonna work out for him too. But
It's
I
not going to.
I don't think so. I don't know how much loyalty there is, like to these people, and that people are saying they saw this happening on the job. I mean, you're going to be allowed to bring those people in.
Yep. All you need is one person to confirm it, and that's, his case is going to be done. I think. Um, I think Secretary Hagstaff is even different. If this had happened with him, I could see the administration getting behind him because I think they really like him. I think Patel is very soon going to be a fall guy for, the some of the actions or inaction of the FBI, and I think he miscalculated his hand here, but who knows? Could be wrong. Uh, I suspect we won't be hearing so much about this lawsuit after this. I think there's a splash, and then you don't hear about it for a while. Is my guess. Um, all right, let's move on. Anything else on that before we move on?
No.
Carnival Cruise was in the news this week in an interesting case in a federal court out of Florida, where a passenger was awarded $300,000 in a case where she sued Carnival Corporation after she claimed that she was overserved alcohol despite being visibly intoxicated while aboard the Carnival Radiance in January of 2024. Uh, the complaint claimed that she fell down a flight of stairs and suffered severe injuries after having been served 14 drinks over 8.5 hours. Um, this case went to trial. There was a week long trial in federal court in Miami, and the jury returned the verdict a couple weeks ago. Jurors found, and we'll talk about this, they found that both Carnival and Ms. Sanders, the plaintiff, were negligent, but they determined that the cruise line was 60% responsible for her injuries. And notably, the complaint alleged that she was swaying, stammering, and slurring her speech, had alcohol on her breath, go figure, and was acting belligerent in front of the crew, who continued to serve her drinks after that. She subsequently fell down the stairs and suffered injuries. Um, this is one of those cases, we were talking about this yesterday, that uh, haters going to hate on this one. I'm sure there's going to be a lot of people comparing this to the hot coffee case, claiming that this is just another example of someone, trying to get money when they don't deserve it. That may, in fact, be the case here. Hard to say, but why don't you explain sort of the challenges in this case and why there maybe was is some fault attributed to Carnival here?
Yeah, I definitely think that this was one of those like, oh, people love frivolous lawsuits kind of clickbait, the fact that it sort of made the rounds. Yeah, I mean, when you look into it a little bit deeper, yes, anybody who's serving alcohol has an obligation to serve it in a responsible manner. And there is a recognition in the law that, we see it primarily with bars, that you cannot serve a visibly intoxicated person. And we've talked about this before on the podcast. In New York State, we have what's called the dram shop law. So if you go to a bar, you're visibly intoxicated, you get overserved, you leave, you get in a drunk driving accident, you kill somebody, the bar is also going to be responsible. This is a little bit different. I think we talked about this with the guy who also was overserved on a cruise and went on like a drunken, violent rampage and then somehow subsequently died once he was in the custody of the security guards. And we sort of talked about that you don't see as often the intoxicated person being the plaintiff because, again, a lot of times, unfortunately, even if a tragedy ensues, there's a lot of fault on the intoxicated person for their actions and sort of contributing to this situation. So, if you look into it a little bit deeper with like a critical eye as an attorney, you can sort of understand what the legal theory is. And my understanding is that the attorney who handled this case for the plaintiff is kind of an expert in cruise ship liability. So, and he acknowledged after the verdict that these are very difficult cases. But, obviously, I mean, she won. And and I do agree that these kinds of things can be sort of a tool. You might feel perhaps you have no sympathy whatsoever for this particular person. That being said, you have to have these kind of standards because there is a situation where she doesn't fall down the step and kill herself. She does something that kills somebody else. And the cruise ship does have some obligation to not overserve people so that that does not happen.
Yeah, the breakdown of the verdict. So this is essentially what's known as a comparative fault situation. So in New York and in many other states, when you sue someone or some company for negligence, a jury is allowed to make an apportionment of fault between the two parties, or if there are multiple parties, between all of the parties, and basically say, "All right, everyone's at fault here, but we think that." In this case, Carnival, you're 60% and she's 40%. I'm not sure how they arrived at that. It's somewhat arbitrary, I think. It seems to me like this lawyer did a good job for his client, convincing a jury that this was not entirely her fault. I guess the argument would be that there came a point at which she lacked any ability to make, credible decisions as to ordering drinks or whether she should continue to be served, and they should have seen that and cut her off. And I think your point is correct. I mean, it's one of those scenarios, and maybe he argued this, that where you're trying to look at this from a more societal picture of, yeah, you can blame this one person, but you don't want to send the message to the cruise ship folks that it's okay to just, serve someone 20 or 30 or 40 drinks, because nothing good is going to come of that, especially when they're visibly intoxicated. That's really the analysis in New York, at least, is was the person visibly intoxicated? Should you have known that you're serving someone who was, uh, at risk?
Yeah, and I don't know if some of the articles that I saw about this were sort of written in the context of highlighting sort of the inherent problem with these all-inclusive cruises. So I mean, there's plenty of all-inclusive resorts, on and off the ocean. And then there's, plenty of people who have the financial means to buy as many drinks as they possibly want. But I do think that, this could be one of those things where if you have more lawsuits like this, it's going to kind of like, quote unquote, ruin it for everyone, because one of the solutions to this is to not have all inclusive. And then if you're going to have to pay $15 for every shot of tequila that you do on a cruise ship, then maybe you're going to stop at, two and not have 14, which is crazy. I'd be dead. I'd be dead if I had 14 shots of tequila,
It's a lot of
right?
tequila. I
I
like
can't even
tequila.
imagine.
That's a
I
lot of
mean, I like
tequila.
tequila too, but at this point
It's,
in my life, I don't think I could do 14
it's
shots
also
of it without, I
probably.
mean, well, she fell down the steps. She's lucky she didn't crack her head open and die.
I've never been on a Carnival cruise, but I can't. My 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 thought, when I was in college, we went to places with all inclusive resorts on break and that kind of thing, and then we've been to one or two in our travels over the years,
I've
and
never been to an all-inclusive resort. I have been to resorts that have an all-inclusive option.
okay,
I
so,
feel that there's a distinction.
yeah, maybe. Excuse me. Anyway, all right. Well, interesting case. The moral of all these stories is that it seems like some folks really like to get their drink on when they go on cruises, and it seems like look, I'm all for having a good time, but you're on a ship in the middle of the ocean. It's probably not the best place to be getting so wasted that you can't, keep your balance, for example. There seems like there's a lot that could go wrong in that environment. So,
Yeah, there is a
um,
case where I don't know if it's an actual lawsuit, but it kind of gets brought up in this context of a woman who's same thing. I think they did sue to try to, at the very least, get more information about what happened, but a woman who went overboard. To me, this is
yeah,
clearly
I
like
think
a
we talked about that.
foreseeable, yeah, prob thing that could happen.
Um, Story in the news today about Sullivan Cromwell, which is, I'm sure there are more prestigious law firms in the world, but not many. um,
Yeah.
One of the most prestigious law firms in the world, uh, which had to apologize to a federal judge because they submitted a court filing that was replete with errors caused by, wait for it, AI, including hallucinations that fabricated case citations. They came in a recent motion in U.S. bankruptcy court in Manhattan, and I'm sure this absolutely must kill this firm. It was discovered by their opposing counsel, who was happy to highlight it, and led to a public apology by the firm, and of course I don't know if it was on the front page of the New York Times, but it was head, it was right there in the New York Times, and I've seen it online all day. So, um, this is interesting because we are litigators. We're in court all the time. I use AI. We have a proprietary software that we use, but I don't use it to write anything that would involve case citations or anything like that. The AIs that I've used have kicked out occasionally case sites, and I've always looked at them, and on most of the occasions, or not most, but many of the occasions, the citations were not only wrong, but they were just to cases that didn't even exist. So it's like it's pretty surprising to me that a firm of this, like at that level, would let this happen.
Yeah, I can't imagine. I mean, we are like a, small law firm, and we would never risk our reputation to do something like that. I remember when I clerked at a firm like that, a Wall Street firm like that, they had a whole orientation for the new people that was like, we will not behave in a way that causes us to be on the front page of the New York Times, which that was the whole point of it, because those firms will be on the front page of the New York Times when they screw up. Um, yeah, I mean, this is just another cautionary tale. I cannot imagine. I really can. I just handed in last week three briefs. I read every single case that I cited in those briefs, and I had a table of authorities that was a page and a half long, single spaced. And I am not working at Sullivan and Cromwell. Maybe I should be. We should be. I just can't, I just don't understand. It's just a cautionary tale. I thought it was interesting just in terms of even, I mean, maybe people don't even realize that AI is like doing this because it doesn't just make up fake cases, but it was saying that it was creating fake language from within a case that perhaps did actually exist. But this is another, and this is why you have to read the case. Because I mean, that's a problem in and of itself. And again, doesn't necessarily save you from, so if you already have it on your radar that AI is going to make up case names, maybe you're double checking that, but you should also be double checking what it's telling you that an actual real case is about, or the language from that case, because that's not going to be solved by you just confirming that the case citation itself is real.
Yeah, I mean, I use AI both personally and in our firm more than you do. I'm a big optimist in terms of what it can do for some of the more mundane tasks in our business moving forward. Um, I don't think it's going to displace senior level lawyers. I do think to some degree it's going to eliminate some of the legal assistant paralegal jobs as time goes on. I could see that happening. I'm
Yeah, I
also,
mean, you use, I just feel like we have to say, I mean, yes, you use AI more than I do, and I am like willing to learn how to use it. I don't want to be like left behind in terms of, advances that are actually helpful. But I mean, it's used more in, like you said, like an administrative sort of clerical almost way of, logistically, drafting a
yeah,
document or something like that. But yeah, I mean, the substance in litigation, the substance of a legal argument or a brief, um, I really don't think should be. I understand that there's ways to use AI as a tool. I mean, I suppose any sort of, Westlaw in general is like theoretically some type of AI. Um,
Yeah.
but you know, we're not like going through the books anymore. But to depend on it for like a substantive legal argument or something that you're submitting to a court without proofreading it or without double checking all that stuff, I just feel like that's super unprofessional. And we've seen in the news judges getting called out for it too, like writing
Yeah. I
opinions
mean,
and the lawyers looking at it and being like, wait a minute, this is not a case that exists.
look, it's like anything else in any business that's using it, which most are at this point. It's just like just double check. You just have to you can't push it off completely, which is why when I see these companies now, and I get that some of them are on the sort of quote unquote cutting edge, but that are, basically building out these AI tools to completely run businesses without any human interaction. I think to myself, like, A, I don't know that anybody wants that. And B, I really don't know in what capacity you can actually achieve that because the human judgment, oversight, strategic thinking, all that stuff is much harder to replace. So that's why I remain optimistic both about AI, but also that it's not going to completely displace us. I do worry about uh, potential spinouts in some of the other areas, but we don't have to talk about that here. All right, let's move on. Very sad and weird story. A driver who struck and killed a jogger in front of his wife has now sued the victim's family for his own emotional damage. Uh, so, Gavin Moss, young man, 25, hit and killed Anthony Miller, a 37-year-old father of two and nurse, while he was on an early morning run with his wife last August. Moss, the driver, said that he moved in order to give Miller's wife room when he saw her reflective clothing, but he did not see her husband, who was wearing dark clothing in the dark and rain, according to the police report. Um, the driver immediately stopped his vehicle, attempted life-saving measures, and interestingly, was not given a ticket for the accident. He blamed it in part on the poor lighting and the weather, and indicated that he's been hospitalized numerous times due to the emotional damage the crash caused. And I think importantly, he's seeking $50,000 in damages in this case to cover his medical expenses and lost income, which I think is a pretty big signal. And why don't you discuss why he has a claim if he does, and what the significance of that $50,000 versus one or two or $5 million is?
Yeah, I mean, going back to the cruise ship case, when I saw this being reported and I saw it pop up in a lot of different publications, I think it was being sort of represented of like, can you believe this? This is her, how could anybody do this? This family is suffering, et cetera. I mean, look, I get that, is this a case that we would take? I don't know, but I don't think so. But I do think, like you said, when you look deeper in and you see how much money he's asking for, I do think this is actually a little bit similar. You brought it up earlier to the hot coffee McDonald's case. So that case has a horrible reputation of being sort of an example of frivolous lawsuits and then frivolous, excessive verdicts because this older lady was awarded, I think, like a significant amount of money, if not over $1 million, somewhere near there, for spilling super hot coffee on herself. And it's kind of like the case that everybody points to as sort of a frivolous type of lawsuit. But if you read about the case more in depth, what you find out is that the lady was seriously injured by this excessively hot coffee. And all she wanted was McDonald's, a gigantic multi-million dollar company, to pay like a few $1,000s of her medical bills. And they refused to do it. So she sued them, which is what you do when somebody won't, when someone has done something wrong and they won't just, have their insurance company pay you. Um, and then ends up winning all this money. So I think it's a little bit unfairly that that's portrayed as sort of a frivolous lawsuit. And I think this is kind of similar. I mean, this might be a little bit more of a stretch perhaps to say that, this poor jogger dressed in, dark clothing in the rain is at fault for this person's, mental health struggles that he's had since this happened. But it does sound like to me, reading between the lines, seeing the relatively minimal amount of money that he's looking for is that he probably put a claim in with these people's like homeowners insurance or something, and wanted them to cover his medical expenses that he's had to deal with after this, and they just refused to. And if they refuse to, and you genuinely, I mean, I don't know, maybe he doesn't have health insurance. I don't, if he genuinely has out of pocket costs, then I suppose this could be the only way to try to recoup any of it.
I think an interesting way to think about this case is let's assume a slightly different set of facts and assume that he was driving his car down a dark road in the early morning hours, and there was somebody out jogging wearing very dark clothes, and that person, for some reason or another, veered out into traffic, which caused the driver to jerk his wheel and run into a tree and break his arm or break his neck. In that case, the driver would potentially have a claim against the runner for negligence, in running down the road in a negligent way and not making himself visible so that the driver could see him. And there, I don't think anyone would really question. They may or may not agree with it, but I don't think they would question whether it was a quote unquote legitimate claim. So I think that's kind of a different way to think about it. He's basically saying, if this guy, if it's tragic, yes, but if he had been wearing appropriate clothing or acting in an appropriate way, this wouldn't have happened. And I don't know any of the facts other than what's been reported, but I think that's I don't think it's ever as sort of like black and white as people tend to believe it to be. Oh, and the McDonald's case was $2.9 million she won.
Yeah. Which, I mean, we've talked about, I feel like we had a run of episodes where for some reason there was a hot coffee case in the news like
Yeah,
every other day. I mean, again, like this case has a bad reputation. That being said, there are standards that sort of exist as to how hot these beverages are supposed to be. And I guarantee that anybody who spills like an excessively hot thing on themselves and gets like a third-degree burn, because this is not like, oh, it's hot, my skin is red, I'm suing someone. This is like, my father had a case like this where somebody dumped like some like molten hot food on someone's lap. I mean, they were like
yeah,
severely injured.
yeah,
So, as you always have to look a little deeper into it. This case is tough. I mean, this kind of goes back to like just because you can judge you sort of
yeah,
situation. This guy's all over the news looking like a callous, horrible person who was suing the estate of a man that, even through no fault of his own, he nonetheless killed in front of his own wife, which is
yeah.
horrific. So, do you really need to sue these people and like rub salt in the wound? I don't know. I mean, I probably not.
Yeah, I think that's fair. That's a fair way to look at it. All right. Let's talk one more topic and then we'll cut for the day. Spoiler alert, if you are watching The Pit and you haven't seen the season finale yet, you may want to stop reading now or stop listening now, or watching. Also, if you're watching The Pit and you haven't watched the finale yet, what are you doing? It came out like 2 weeks ago, so go watch it. Um, anyway, in the finale, there is a scene involving um, a new attending. Let me back up. If you don't know what the pit is, I'd be surprised. The pit is basically a new version of ER. Stars Noah
Oh, no,
Wiley.
you
And
can't say.
you can't say that
You're
actually.
kidding. So
Yeah,
they're getting sued for that.
yeah.
Maybe.
But it is. It's a show that takes place in a trauma center emergency room in Pittsburgh, and stars Noah Wiley, coincidentally, who also was on ER, and it goes on an hour by hour episodic run of happenings in the trauma center. One of the characters this year was a new attending physician in the hospital, who, throughout the course of the season, appeared to have a couple of episodes while she was in with patients where she kind of froze and she had kind of like a frozen look on her face. Turned out that she had um, a seizure disorder, and she disclosed it to the Noah Wiley character, who is like the main character on the show during the last episode. And why don't you talk about what that has to do with us in our practice?
Yeah, so in the conversation that it's Dr. Alashimi she has with Noah Wiley, you kind of get these little foreshadowing throughout the season where she has a couple episodes where she's sort of like staring into space. So you sort of know that something is up with her, and then he's kind of been had his guard up with her from the beginning, probably more so because he feels like she's stepping on his toes. But he witnesses one of these space outs and sort of really jumps on it. And then, and is asking other doctors about it. And then she herself, kind of her own accord, discloses it to him. And what's relevant to our practice is in the course of the conversation that they're having, he is really like, you cannot do your job. Your job is to react in the moment. And if you space out for 5 seconds, you could literally potentially kill someone, which I think is probably true. And her sort of response and going back and forth with him, I think she has a little bit of and I think this is actually something that we probably see in our practice where because she's so sort of emotionally invested in it and emotionally and professionally invested in her job, may have a little bit of a, warped sense of what her abilities are and what might be reasonable in terms of the workplace in a way to accommodate her. So I think ultimately, kind of reading between the lines as an employment attorney, in the course of this conversation, she basically is sort of asking him for an accommodation, because she is basically saying that I may not have to actually do some of this super in-depth, I don't know if the right word for it is like clinical work, but like she may not have to actually do in her position the super hands-on work. And also she suggested sort of having a backup attending physician, perhaps to just step in on that type of thing if she, maybe she would act in a more sort of like oversight role or something as opposed to like getting her hands dirty.
Yes, because he denies the accommodation because
Yeah, well, he says, I mean, he basically is like, well, I have to go and, report this if you don't do it yourself, because, yeah, so the standard on an accommodation, um, well, it's sort of two separate issues. In order to be protected by disability discrimination laws in the first place, you have to be able to perform what's called the essential functions of your position with or without a reasonable accommodation. So I think there's like two arguments to be made here. And then the other one is, so, okay, so you are theoretically protected by the disability discrimination laws. You've now asked for an accommodation. Then the question is, does the accommodation pose an undue burden on your employer? So I think the issue in her situation is sort of twofold. One is, are the essential function is one of the essential functions of an attending emergency room physician to be in there getting your hands dirty, actually doing the procedures that are life-saving procedures, um, such that if you are going to space out in the middle of that, then not only would that theoretically kill someone, but there's really no way to remove that job duty. And if you can't remove that job duty, then I think the argument is that you can't perform the essential functions of your position. Therefore, you're not even covered by the law in the first place. And I think in the context of the pit, Noah Wiley is certainly in there getting his hands dirty, saving lives, throughout the day. So I'm sure that would be his position, is that you can't do this job without being available to do that type of work. Safe though that you get on to the next step of, am I entitled to a reasonable accommodation? You go into this undue burden analysis. What I thought was sort of relevant in this situation is she's saying, well, there should be two attending physicians. So basically, I have a backup, or I can do, this other type of oversight work, and then this person can back me up. I think that would be sort of the undue burden analysis of like, well, what does that mean? Do they have to hire someone? It's not inexpensive to hire a high level, attending physician when theoretically you only need one. So I don't know that someone would, in a lot of situations, would ever really typically be entitled as a reasonable accommodation to have an entirely new person sort of be hired as a backup for you. I mean, there are situations where you might have to have like an interpreter or this or that, but sometimes these are people who are already employed in some way, and that's part of their job is to give support to other people. But to have a whole other doctor in there backing you up, I would think would be potentially quote unquote unreasonable.
Yeah, the most and the critical part in employment cases, in the employment context in New York at least, is engaging in what's known as the interactive process, which is engaging with the employee to determine if there's something that you can do to help them, or if the request is simply unreasonable and they can't do the job with or without the accommodation. So uh, this is, that show. We're obviously not doctors. The show seems relatively accurate, and so that was an interesting portrayal of kind of some of the stuff that does actually happen in the workplace from an employment law perspective that we see. So yeah, thought it was interesting. Good closure to the season. A little less consistent than last season, I think, but it was still good.
Yeah, I like that show. It's a good show.
Okay, anything else?
No?
All right. We will wrap there for this week. Thanks for listening. Reminder that you can find us on Instagram at Litigious Podcast. If you have questions, feel free to hit us up there and keep on liking, subscribing, and sharing. We will be back again probably next week with another episode. We will talk to you soon.